everyone, and welcome to the 9th episode of Corporate Law Updates by Corporate Law Journal. In this episode, we'll be discussing the weekly updates by SEBI, MCA, and RBI. Let's start this episode by discussing the amendments to the operational guidelines for investment advisors in the IFSCs. First, that it is applicable to all investment advisors. The operational guidelines for investment advisors were issued by SEBI on January 9, 2020, and the amendments have been made in Clause 3, 4, 8, and 9. The guidelines for the same are as follows. The applicant who already is a company in IFSCs doesn't have to form another company. The IAs shall ensure to comply with the applicable guidelines while dealing with NRIs seeking investment advisory services for them. The IA, that is parent entity, shall fulfill the net worth requirement separately and independently for activity undertaken. An IS shall ensure to conduct the annual audit from CA and CS in compliance with the investment advisor regulations. Now let's move on to the recovery of assets of defaulter member and recovery of funds from clients of defaulter member. SEBI in 2018 had specified early warning mechanism to prevent diversion of client securities and consequential actions to be initiated by the stock exchanges, clearing corporation and depositors. SEBI had previously specified in 2017 that all security exchange shall initiate the process to settle debit balance by selling their securities if such clients fail to clear their debit balance after giving notice period for 5 days. Further, in July 2020, it had also notified the standard operating procedure in the cases of trading member leading to default. In the present circular, it is notified that bylaws of security exchange provide for the procedure of declaring a member as defaulter and also provide for initiation of proceedings in a court of law and take suitable actions for liquidating of assets within 6 months of such default. The third amendment is Preferential Issue and Institutional Placement Guidelines by a listed real estate investment trust and infrastructure investment trust. SEBI issued a circular in November 2019 to provide for the guidelines for preferential issue and institutional placement of units by listed real estate investment trust and infrastructure investment trust, which was subsequently revised in March 2020. Due to the situations arising out of the COVID-19 pandemic, SEBI has granted certain relaxations for raising of equity capitals. On similar lines, the guidelines for preferential issue and institutional placement listed Real Estate Investment Trust and Infrastructure Investment Trust stand modified as set out in the annexure to this circular. The relaxation of validity of SEBI or observations and revisions in issue size. SEBI, by circular of 21st April, had provided with certain relaxations pertaining to validity of SEBI observations and filing of fresh offer document in case of increase or decrease of issue size beyond a particular threshold. After considering the representations made to the extent said relaxations, it has now been decided to revise the issue size up to 50% and to further relax the observations up to March 31st, 2021. The validity of SEBI observations shall be subject to an undertaking from lead manager to the issue confirming compliance with the ICDR Regulations 2018. The circular shall come into effect from October 1st, 2020. Now let's have a look on the monitoring of foreign holding in depository receipts. In 2019, SEBI had notified the framework of issuance of depository receipts by a listed company where the obligations of Indian depository and domestic custodian were mentioned. The said circular provided that the Indian depositories shall have necessary arrangement with the domestic custodian and foreign depository. After discussion with market participants, the board operational guidelines for the same are placed at annexure. Indian depositories, in consultation with market participants, may prescribe the necessary arrangements to operationalize the same. The relaxation in timelines for compliance with regulatory requirements are applicable to all recognized stock exchanges, trading members, clearing corporations, and KYC registration agency. In view of the situation arising due to COVID-19 pandemic, lockdown imposed by the government and representations received from stock exchange, SEBI had earlier provided relaxations in timelines for compliance with various regulatory requirements. Review of provisions regarding valuation of debt and money market instruments. According to the SEBI circular of September 2019, the valuation agencies engaged by AMFI recognize default of security, and the said provision was relaxed by SEBI circular of April 2020 up till the period of moratorium permitted by RBI. SEBI on August 31, 2020 has provided relaxation to credit rating agencies in case of default for restructuring by the lender investors solely due to COVID-19 related stress. Further, if the valuation agency is of the view that proposed restructuring is solely due to fallout of COVID-19 pandemic, then the valuation agency may not consider the restructuring. Non-receipt of the duties as default for the purpose of valuation of money, market or debt securities held by mutual funds. The above modifications shall be in force till December 31st, 2020. The standard operating procedure in case of trading member, clearing member leading to default. SEBI circular of July 2020 notified that TMs or CMs are required to provide a list of all their bank accounts to the stock exchanges, and security exchange shall obtain an undertaking cum indemnity bond from the TM within 90 days from the date of release. It has been decided to extend the timeline for submission of the undertaking by the TM for all the bank accounts till October 31st, 2020. It has also been decided to provide flexibility to the security exchange for modifying the undertaking. Now let's have a look on the press release that was issued pertaining to the board meetings. The SEBI board amended the following regulations. First, Debenture Trustee Regulations 1993. Second, Issue and Listing of Debt Securities Regulation 2008. Third, Listing and Disclosure Requirements Regulation 2015. Fourth, Delisting of Equity Shares Regulations 2009. Fifth, Mutual Funds Regulations 1996. Sixth, Alternative Investment Funds Regulations 2012. Seventh, Prohibition of Insider Trading Regulations 2015. It was also decided to set up a limited purpose repo clearing corporation and disclosure of information related to forensic audit of listed entities. Now let's move towards the MCA notifications. First, Extension of Companies Fresh Start Scheme 2020. The scheme was so issued as a General Circular number 12 on the 30th March of 2020 till 31st December of 2020. Second is the extension of LLP Settlement Scheme 2020. MCA has decided to extend the scheme so issued as a General Circular number 13th on 30th March 2020 till 31st December 2020. The third is extension of time scheme for relaxation of time for filling forms related to creation or modifications of charges under the Companies Act 2013, where MC has decided to extend the scheme in the General Circular number 23 dated 17th of June till 31st of December 2020. The clarification on passing of ordinary and special resolutions by companies under the Companies Act 2013 read with rules thereunder on account of COVID-19 extension of time. MCA has allowed companies to conduct their EGMs through VC or OAVM or transact items through postal ballot, which should be in accordance with the framework provided in the general circulars published previously. Now, let's start with the amendments in the Companies Act 2020, which was published on 28th of September 2020 in the Gazette of India. First, Decriminalization of Companies Act, which removes imprisonment and substitutes fine by penalty and reduces the amount payable as penalty across the board. Second, exclusion from listed companies, that empowers the center in consultation with SEBI to exclude companies that issued specified classes of securities from the definition of listed company provided in Section 2, Clause 52 of the Companies Act. Third, exemptions for filing resolutions. Companies have to file for certain resolutions with the registrar. Banking companies are exempted from filing the resolutions, further extended to registered non-banking financial companies and housing finance companies. Fourth, CSR, which exempts the setting up of CSR committees to the companies having CSR liability of up to Rs 50 lakhs under Section 135 of the Companies Act by inserting Clause 9. Fifth, NCLAT benches provides for the establishment of National Company Law Appellant Tribunal in New Delhi by inserting the Section 418A. Sixth, listing directly in foreign jurisdiction, which provides the power to central government to allow certain classes of public companies to list classes of securities in foreign jurisdiction by inserting Clause 3 and 4 in Section 23 of the Companies Act. The clarifications with regard to creation of deposit repayment reserve of 20% under Section 73, Clause 2, Subclause C of the Companies Act 2013 and to invest or deposit 15% of amount of debentures under Rule 18 of Companies Share Capital and Debentures Rule 2014. COVID-19 extension of time regarding extension of time in respect of matters referred to in para 5, 6 of the circular number 11 from 30th September 2020 to 31st December 2020. The extension done by keeping in view the request received from various stakeholders seeking extension of time for compliance of the subject requirements on account of COVID-19. Let's start with the RBI notifications. Basel III Capital Regulations Review of Transitional Arrangements. The implementation of last tranche of 0.62% of the capital conservation buffer has been deferred from September 30th to 2020 to April 1st, 2021. The minimum capital conservation ratios given in the circular of 16th July 2015 on Basel III capital regulations will be applicable after the CCB attains the level of 2.5% on April 1st, 2021. Basel III Framework on Liquidity Standards Net Stable Funding Ratio NSFR guidelines was given in the circular dated March 27, 2020. Due to uncertainty prevailing because of COVID 19, the implementations of NSFR has been delayed by another 6 months and it will come into effect on 1st April 2021. So that will be all for today. Do like, share and comment on the video and subscribe to our channel for more updates. Thank you.